Okay, if I could have everyone's attention.
Very good.
If I could have everyone's attention, please. My name is Howard Wright, and I'm co-chair of this event. On behalf of CABLE, the Canadian Association of Black Lawyers, and the Law Society of Upper Canada, I would like to welcome you to our panel discussion this afternoon.
Good afternoon, everyone. I wish you a jolly good afternoon, and I thank you very much for joining us today to what I consider to be a rather dynamic discussion, making a comparison between equality rights in Canada and South Africa. You have just heard from my young colleague, Howard Wright. He is the co-chair of the planning committee, and that consisted of Rudy Tixon and Jose Bouchard. They're in the audience, but I want you to give them a round of applause for the effort that they have contributed. Howard is our Master of Ceremonies. Howard is a graduate of Carleton University, where he attained his BA, and he attained his LLB from the Queen's University, did his articles at Borden Ladner Gervais LLP in Ottawa, and was called to the bar in 2002. By profession, he's a barrister, a very upcoming barrister who's very dedicated and passionate about his work in the area of civil litigation, corporate work, and in representing matters before tribunals and regulatory boards as well. Howard has arranged a rather delightful evening for us, and I shan't say any more than this, but please don't miss it. Focusing on the event before us, the discussion, I have the honor of introducing the panelists. And I'm going to start from my very near right. And I am going to introduce them in the order in which they will be speaking. And I'm going to ask your permission to sit, if you don't mind. Thank you. On my immediate left is the Honorable Stephen T. Gouge, a member of our esteemed Court of Appeal in Ontario. Justice Gouge will present an overview of equality in Canada in the context of Section 15 of the Canadian Charter of Rights and Freedoms. And he would talk about its evolution for the last 20 years, or perhaps the lack thereof. Justice Stephen Gouge was appointed a judge of the Court of Appeal for Ontario in 1996. He received his BA and LLB from the University of Toronto, Master of Science in Economics from the London School of Economics. He was managing partner of Gowling Strathy and Henderson in Toronto, where he engaged in general litigation practice and was appointed as a Queen's Counsel in 1982. Justice Gouge has appeared before many administrative tribunals and courts of all levels in Ontario and the Supreme Court of Canada. He has lectured at the University of Toronto Faculty of Law in both labor law and native rights in 1994 to 1985. He was counsel to the Office of the Premier of Ontario in 1989 and a bencher of the Law Society of Upper Canada from 1991 to 1996, and he's a fellow of the American College of Trial Lawyers. Our second speaker will be Joel Amor. I hope I'm pronouncing your last name correctly, Joel. Joel is a lawyer, and she is a candidate for Masters of Law at the University of Cape Town, South Africa. Joel will provide a brief social and political historical overview of equality rights in South Africa and compare equality rights jurisprudence in the Constitution of Canada and South Africa. Joel will also discuss the equality test applied by the Supreme Court of Canada and South Africa in their constitutional cases dealing with equality rights, with particular emphasis on the interesting dynamics of rights claimants. To tell you a bit about Joel, she's a human rights lawyer, researcher, is a graduate of McMaster University, the University of Ottawa Law School, and as I mentioned earlier, She is a master's candidate at the Cape Town University in South Africa. Her areas of interest and expertise is the intersect of race and gender equality rights. As an equality rights advocate, Joel was focused on issues affecting members of vulnerable communities in Canada as well as various parts of South Africa. Joel has been involved in equality rights, advocating and policy writing with the African Canadian Legal Clinic. As a legal researcher with the Law Society Equity Initiative Department, Joel contributed to the department work in enhancing equality within the legal profession. And in the international area, Joel's work in human rights with the NGOs, non-government organization that is, in Namibia and Malawi, has exposed her to the issues of injustice and inequality that plague the peoples and communities of South Africa. Next to Joel is a dear friend, Professor Joanne St. Louis of the University of Ottawa, Faculty of Law. I can actually tell you a lot about Joanne without reading a script, but to time myself, I shall read my script. Joanne will focus on the South African land reform process in light of the Canadian experience with Aboriginal land claims. It will contain a reflection on differing constitutional responses to colonial incursion, the impact of legal culture, and the challenges of majoritarian democracy shaped by distinct histories will also be discussed. Questions that will be explored include: to what extent are the systems even comparable? How does a policy of non-racialism in post-apartheid South Africa affect the capacity to respond to a critique based on Aboriginality? Can we take any lessons from this comparison? And knowing Joanne, I am sure that we walk away with a lot of information. As I mentioned earlier, Joanne is an assistant professor of law at the University of Ottawa, Faculty of Law. She's a bencher of the Law Society. She has extensive experience in the equality area. She has co-chair of the Canadian Bar Association Working Group on Racial Equality. She has held positions with the Ontario Human Rights Commission and the Ontario Race Relations Directorate. She has also been the executive director of the Women Legal Education and Action Fund, fondly known as LEAF, and served as the special assistant to the government affairs to the Grand Chief of the Cree of Quebec. And our last person at the very end of the table is Estella Moyenwe. She's a barrister and solicitor. She's a master's candidate at Osgoode Hall Law School. Estella will discuss the comparison of equality rights in Canada and South Africa. She will focus on the influence of social and economic factors in the construction of equality rights and discuss the enforcement of equality rights in both jurisdictions. Estella is a member of the Manitoba Bar, the Northwest Territory Bar, and the Bar of Ontario. She was the first executive director of the first legal aid clinic in the Northwest Territories, Beaufort Delta region. She has worked as a policy analyst at the Court Challenge Program of Canada and policy and research lawyer at the African Canadian Legal Clinic. She's currently in the process of completing her Master's of Law thesis in Alternative Dispute Resolution at Osgoode Hall Law School. Previously, she was a non-bencher member of the Manitoba Law Society Equity Committee, board member of the Women's Legal Education and Action Fund, and the Women's Health Clinic. She has published a number of articles and presented papers on the Charter of Rights and Freedom and various topics on the law at numerous conferences. To a dutiful, attentive audience, I give you an august panel, and I'm sure they'd have you enraptured in information. Each panelist would speak for about 5 minutes, Then we'd have some questions, and then we would invite your participation by asking the panelists questions. We shall start with Mr. Justice Couch.
Thanks, Patricia. We talked briefly on the telephone last week, and thought what we might try and do is I'll begin by setting the Canadian context, and then you'll hear from the experts on my left something of the South African experience in the Canadian context, and then we can perhaps just engage in a dialogue, because I think all of us who have any window on equality law know how much various parts of the world have to learn from each other in this broad area. I thought I'd begin by just perhaps going back in history beyond the enactment of the Charter in 1982 and see if I could give you just a very brief thumbnail sketch from my perspective of the way equality law has developed in Canada, really from its inception. It's not always been a proud history, far from it. It reflects in many ways, and reflects today the Canadian history, beginning with the three founding cultures, the Aboriginal, French, and English, but also reflects the significant waves of immigration that have been a major part of the social fabric of the country over the last 150 years particularly. And the notion of accommodation by the dominant majority of disadvantaged groups has come to be central in our thinking about equality. But it wasn't always that way. The law has played a significant role throughout, and as I say, not always a proud role. To go back to where one can first discern sort of any role for the law, I thought what I might try to do, and this division into kind of three epochs or three stages of equality law in Canada is not mine. It comes from a really good article by the Chief Justice of Canada that she wrote in 2002 in the International Journal of Law and Equality. And the phases she referred to there begin with the very first phase, which really ran to the middle of the 20th century, when, if anything, legal institutions and the law served simply to reinforce notions of discrimination and inequality. And one can recite the kinds of cases that we all know about, the case in Saskatchewan where the Supreme Court upheld the Saskatchewan law prohibiting Chinese men from employing white women. The case in 1940 where the Supreme Court, this is a case out of Quebec, upheld a policy of a bar not serving blacks on the basis of the notion of freedom of contract, without a whisper except in one dissent of any notion of equality. Those two are representative of spots of cases throughout that early period in Canada's history where the law was, if anything, antithetical to notions of equality. There are one or two bright spots. We all know about the Persons case in 1930, but those are few and far between. The first phase then moves on post-Second World War, I think, to what Chief Justice McLaughlin calls the equal opportunity phase, fueled, I suppose, in part by the desperate human tragedies of the Second World War and the world as it stood then. There were the beginnings of legislative address of discrimination and inequality. In 1944, Ontario passed the Racial Discrimination Act. It did nothing more than prohibit expressions of racism. In 1947, Saskatchewan enacted the first Bill of Rights. Both of those were, as we would view them now, significantly inadequate legislative instruments. They both dealt really on a quasi-criminal basis with any kind of discrimination, nothing more sophisticated or practicable than that. But at least it was a start. In 1951, Ontario passed its first human rights law, which changed the model a little bit to adopt notions of investigation, conciliation, and ultimate decision-making about complaints of discrimination in a forum that wasn't as quasi-criminal as the first two pieces of legislation. And by the mid-50s, other provinces, there were 5 other provinces by that stage that had passed similar pieces of legislation. At the global level, of course, there was the hallmark document, the United Nations Universal Declaration of Human Rights in 1950, which provided, in effect, the international backdrop for this kind of evolution. And then in 1960, domestically, what I guess those of us who stem from, regrettably, that generation called the Diefenbaker Bill of Rights. It was a shadow of the document we have today. It was simply a statute, as you know. It had no constitutional effect. Its effect was limited to federal legislation. It had no impact at all on provincial legislation. And to make it worse, it was a document that was used in very, very uncourageous ways by the courts. In its lifetime, it provided the strike down of only one piece of legislation in the Dry Bones case involving natives off reserve intoxicated, and the legislation making that an offense was struck down. But for example, in the Bliss case, the unemployment insurance regime was found lawful even though it provided that women who had to go off work for pregnancy were as unemployed as anybody else. And got no benefits. So there were significant shortcomings in the world as it stood in the early 60s. A phase that was earmarked, I think, rather more by equality of opportunity rather than the kind of notion of substantive equality that we have today. Equality of opportunity, trying to articulate that as simply providing everybody with the opportunity to maximize their potential without the kinds of considerations of entrenched and embedded pre-existing disadvantage that substantive equality is designed to address. So the second phase, in effect, runs from, roughly speaking, the end of the Second World War until the early part of the 1980s. And then, of course, in the 1980s, we moved to what we have now. That is a regime where the overarching equality document is Section 15 of the Charter of Rights and Freedoms. You all know about that. The little squib about what I'm supposed to say says I'm supposed to explain the last 20 years of case law under Section 15. It can't be done. I certainly can't do it. What I can give you is a couple of thoughts about it, and then a little bit about the kinds of tools that Harry and Russell, I saw him here earlier, and I try to use in our day job when we get Section 15 cases. First, it is a response in part, I think, to the notion that the principle of equality of opportunity was not enough to overcome the embedded pre-existing disadvantage that minority groups have experienced in Canada, and that notions of affirmative action were being seen as social progress here and in the United States. You will all know about the Bakke case in 1977, which dealt with affirmative action in university admissions. That's been a subject not free of controversy in the United States. The Supreme Court, in essence, reversed Bakke 20 years later. But there were responses of a similar kind in Canada. The employment equity legislation that the provincial government passed in 1993. Those are reflected in the way in which the charter jurisprudence, I think, has evolved. It is a constitutional document, and that's a fundamental bedrock of its importance. The approach to substantive equality was embedded in the jurisprudence very early in the Andrews case, where the court, in a very deliberate choice, articulated substantive equality rather than formal equality as the engine room of equality law in Canada. Meaning by that treating everybody identically does not achieve equality. There has to be a real look at the source of the disadvantage and the way it impacts on the daily lives of those in the disadvantaged groups. in order to have the real equality that substantive equality tries to achieve. It's a process we obviously are still learning. In the 15 years between the proclamation of Section 15 in 1985 and 1999, there was a great deal of fine-haired division of jurisprudence within the Section 15 chapter in a casebook on charter jurisprudence. That kind of came together in a case that I guess, if any case has succeeded in doing it, has laid out the present blueprint for equality law in Canada, and that's the Regina and Law, a case decided in 1999. I'll just put out the stepping stones that the court gave to us then for equality law, since it may provide a bit of a touchstone for discussion compared to the concepts used in South Africa. There are 3 steps, as you all know. It's relatively straightforward, although terribly difficult to apply. The first is the law or the government action that's under scrutiny has to create differential treatment as between the individuals asserting inequality and a comparison group that is in some way similar to the disadvantaged group. The differential treatment, secondly, has to be based on some form of explicitly enunciated ground in Section 15, or a ground analogous to the grounds that are specified as prohibited grounds in Section 15. And you all know the list. The court has added some analogous grounds and has a methodology in its jurisprudence for what can be additional analogous grounds. So that's the second building block in the puzzle. And the third is the result of the differential treatment on the prohibited ground must be discriminatory. And in essence, that's hard to distill into a sentence, but in essence it's designed to determine whether or not the differential treatment impacts adversely on the human dignity of the individual or group in a way that is unacceptable and reinforcing both of the disadvantage and the stereotype. That's a vastly oversimplified recitation of the fundamental notion of equality law as we have it now. Its fundamental for me is that it is aimed as best we can do it at achieving substantive equality. How we apply it over the course of the next 20, 30, 40 years will determine how well we achieve that objective. So we've come some distance. We've got a long way to go, and we have a lot in our past that we shouldn't be proud of. But that's where we are today, and we'll see where we get to over the next generation. Thanks, Patricia.
Thank you, Justice Gouge. I can't say I was timing you, but it's pretty close to the 5-10 minutes that was allotted.
We have time limits in our court, so I'm kind of used to it.
We now hear from Joelle. And what is interesting in Joelle's presentation, I believe she's going to touch off on parts of what Justice Gouge has said with respect to the substantive test, and with considering that in the light of what might be a test in the application of this substantive test, particularly intersectionality.
Thank you, Patricia. I'm going to divide my discussion into 3 sections primarily. First of all, what I'm going to do is give some general comments about equality and intersectionality, as Patricia has mentioned. I'll try to give a brief explanation of intersectionality, but I think essentially the best way to describe it is it gives effect to substantive equality in the sense that Justice Gouge has just described it. That will be the first portion. For the second portion, I'm going to talk a little bit about the historical and social context of South Africa and the fabric that that has set up, and how that becomes the background against which contemporary equality rights in that country are to be applied. And thirdly, I'm going to discuss two fairly recent cases of the Constitutional Court in South Africa to give an example of more or less a good way and a bad way of incorporating intersectionality in social context. To begin with, in considering the development of equality in Canada and South Africa, I take the position that the contemporary realization of equality is dependent upon personal identity. That is essentially who one is, what your personal characteristics are. And so those personal characteristics will either propel or inhibit the attainment of equality. The identity, which is those characteristics which make up individuals, is comprised of any number of factors such as race, gender, age, ability, etc. And they intersect to dictate the ways in which individuals experience the world at any given time. These primary intersections then give way to what I call secondary intersections, such as socioeconomic status, marital status, geographical location, etc. And they form the social context within which one experiences the world. And it's within this realm of social context that equality and discrimination become particularly relevant. This relevancy is determined by the comparative nature of equality and discrimination. I'm not going to go into that in too much detail, but essentially equality is a comparative concept. So your attainment of or access to equality is dependent upon comparing you or your situation to another individual or group. Despite the intersectional identities that characterize equality rights claimants, equality has traditionally been understood and applied in hierarchical rather than intersectional terms. What that means is that conventional equality always functions to reduce the experience of discrimination to one primary characteristic, either race or age or gender or ability, etc. And the other characteristics are layered upon this. But since human beings themselves cannot be reduced to one identity characteristic at a time, the failure of equality analysis to completely address the impact of discrimination on all the intersecting aspects of a person's identity is the failure to protect the dignity of the whole person. I mentioned dignity there briefly. Dignity is something that is usually tied in with equality. So in the attainment of equality, you look at whether or not the individual has also been indignified in some way. In South Africa, they provide a particular section for the attainment of dignity. So just as our Section 15 provides a claim for equality, they have a section which provides for equality and a separate one for dignity. The point just there being that there's this inextricable link between dignity and equality, and they're bound up together. The selection of Canada and South Africa as focus sites for this discussion is based on their similarities in terms of the development of equality jurisprudence. But the similarity does not in any way suggest that Canada and South Africa are readily comparable on the basis of history, politics, or economics, which are some of the traditional social context elements within which to understand the operation of equality. However, despite differences between the two societies, the approach that each has taken in this equality analysis leaves more to be compared than contrasted. In the interest of time, I'm not going to discuss the two tests. Justice Gouge explained to you the Section 15 law test that is applied in Canada, and the South Africans apply a very, very similar test, but the differences are really semantic. I'm not going to go into that. The present argument for an equality analysis that reflects consideration of intersecting identities as well as social context was supported by Justice Claire Leroux-Dubé in the following comment, and I quote, "Given the varying and diverse experiences of children, men, people with disabilities, members of religious and ethnic communities, people who are poor, and indeed all other types of human experiences which may form the background against which the law is applied, we are faced with the inevitable question of what to make of these differences. Will we ignore them, discount them, perceive them as a stereotypical category, or will we face them head on and seek to understand them and the consequences which they bring in our society, even when this may uncover some uncomfortable truth about our own history or relationship with others?" Consideration of context is not restricted to the current state of events, but also relates to instances of historical advantage and, of course, disadvantage. This consideration of historical disadvantage is particularly relevant in South Africa in light of its apartheid past. Very quickly to turn a little bit to the history of South Africa. Again, I'm not going to go through the whole timeline or chronology of apartheid or even the pre-apartheid policies in South Africa, but suffice to say that from the time when the Dutch first laid claim to the territory in 1652 thus displacing and dispossessing the San and Khoikhoi peoples who had traditionally occupied that land. Up until 1990, when Nelson Mandela was released from prison, South Africa was committed to legislation and policy that functioned to segregate and discriminate against its population on the basis of race. Note that although apartheid was not official state policy until 1948, most legislation prior to that point was directed towards inequality amongst the races. Now, when I discuss one of the cases later on, you'll just see how some of the historical pre-apartheid legislation has remained in existence today and is the cause of some of the equality claims that come before the Constitutional Court. The democratic elections of April 1994 and the inauguration of Nelson Mandela in May of that year shepherded the dawn of a new South Africa based on freedom, justice, equality, and dignity for all. The Constitution sets the backdrop against which all endeavors, judicial or otherwise, will be analyzed and applied. Now I'll move into the third section where I look at two cases. And these are cases that I've just randomly selected. The first case, the President of South Africa versus Hugo, is a 1997 case, and one of the earlier cases in which they applied the new South African Constitution. And the facts of that case, in June 1994, shortly after Mandela had been inaugurated, he signed a presidential act which gave special remission to the following three categories of prisoners. Firstly, young persons under the age of 18 on the day that Mandela was inaugurated. Secondly, mothers of children under 12 on the date of the inauguration. And thirdly, disabled persons. In selecting the special remission category of mothers with minor children, the President indicated that he, and I quote, was motivated predominantly by a concern for children who had been deprived of the nurturing and care which their mothers would ordinarily have provided. Having spent many years in prison myself, I am well aware of the hardship which flows from incarceration. I am also well aware that imprisonment inevitably has harsh consequences for the family of the prisoner. Now, the applicant in the case, Mr. Hugo, was a widower and the father of a boy under 12 on the specified date. And Mr. Hugo challenged the act on the basis that it violated the equality provisions of the Constitution insofar as it discriminated against him on the basis of sex or gender, because he would have qualified for the special remission had he been female rather than male. He also claimed that the act indirectly discriminated against his son because his incarcerated parent was not female. Although in writing the majority decision, Justice Goldstone acknowledged that President Mandela's motivation for selecting the categories that he did was steeped in stereotype and generalizations, the decision did not offer any means of correcting or alleviating this stereotype. And just to refer you to one of Justice Goldstone's comments, he says that the generalization upon which the President relied is therefore a fact which is one of the root causes of women's inequality in society. That parenting may have been emotional and personal rewards for women should not blind us to the tremendous burden it imposes at the same time. It is unlikely that we will achieve a more egalitarian society until the responsibilities for child rearing are more equally shared. Now, this comment indicates a clear observation of the stereotype as well as the negative consequences that result. But the decision does not reflect a full consideration of the social context into the remedy. It's noted, however, that the discrimination inherent in the Presidential Act did not escape the notice of the court. And again, I refer to Justice Goldstone's comments that in this case, two groups of people have been affected by the act. Firstly, there are mothers of young children who have been afforded an advantage, which is early release from prison. And secondly, fathers have been denied that advantage. The President released three groups of prisoners as an act of mercy. Now, the three groups, disabled people, young people, and mothers of young children, are all groups who are particularly vulnerable in South African society. And in the case particularly of the disabled and young children, there are groups who have been victims of discrimination in the past. The release of mothers will in many cases have been the real benefit to children. And that was really the primary purpose or the motivation behind Mandela's Act in the first place, was to look towards the best interests of the children. Being told that my time has run out, so.
I'm just passing it along.
It doesn't come from you.
I find it quite interesting.
Okay, I'll try to speed it up.
I think, well, I can end the discussion of that case, then very quickly move to the second. But just to summarize the Hugo case there, so although there is an appreciation and acknowledgement on the part of the court that there was discrimination in the decree set by Mandela. This discrimination was not found to be unfair because it provided an advantage to what was seen to be the ultimate benefactors, and those would be children. Now, my argument would have been to substitute the category of mothers to read single parents of children. So then you would have people in the position of Mr. Hugo, whose wife had died, and his son had no other living parent, had no other parent. He would then be able to be granted the release under that provision. And to me, that seemed to be something that would look more at the intersecting social context and also meet the goal of serving the best interests of the child. I'm going to try to borrow somebody else's time for just a couple minutes here while I talk about...
I'm going to give over my time. Since I'm next, right? Well, here, have some minutes here.
Talk about the second and the last case, which is Bay v. Kailicha Magistrate. Bay is a case of the Constitutional Court of South Africa that was released in October in 2004. Now, what happened in Bay, it was an application by a mother on behalf of her two minor daughters to, well, see, I tried to condense it, and now I've missed some of the beginning facts. Sorry, just 1 second while I get my bearings. Okay. What happened was you had a mother and a father who had been living together, not in a civil marriage nor under a customary African marriage, but they'd been living common law for about 10 or 12 years, and 2 children were born of that marriage. The mother and the father were essentially quite poor. They lived in an informal settlement just outside of Cape Town. They had gotten government subsidies to purchase the land on which the temporary shelter was set up, and they were in the process of building a home. However, before the home was complete, the father died. Now, one of the archaic laws of South Africa that I made reference to before was the Black Administration Act of 1927. Now, essentially what that act says is that any time an African died without a will, then his estate would be devolved under customary law. Customary law follows a rule of primogeniture, which says that only males can inherit. So here you have a common law spouse and 2 daughters, neither one of whom were capable of inheriting under customary law. So what the Bay application is a challenge of the application of this law, which says, the estate has to devolve under customary law. Obviously, customary law was discriminatory against women and children. After the father died, his estate devolves to his father, who quickly wants to sell the property and all the immovable property as well in order to pay for the funeral expenses of his son. In the end result, of course, the mother and the daughters would be homeless. So they want an application to stay this. They receive that at first instance, but in any case, the case goes all the way to the Constitutional Court. Now, what happens there is Justice Langa at the Constitutional Court, in referring to the section that the mother and the daughters are challenging, says that it's part of an act which was specifically crafted to fit in with notions of separation and exclusion of Africans from the people of European descent. What the act in fact achieved was to become a cornerstone of racial oppression, division, and conflict in South Africa, the legacy of which will still take years to completely eradicate. Now, proponents of the policy of apartheid were able, with comparative ease, to build on the provisions of the act and to perfect a system of racial division and oppression that caused untold suffering to millions of South Africans. Some parts of the act have now been modified, but most of the sections, particularly the one being challenged, remains and serves to still haunt many of those Africans subject to the parallel regime of in-state secession in which it creates. In the court, in saying that they're not going to permit the application of that section of the law, there are a couple things that they look at. First of all, customary law is of equal value and worth as is civil or statute law in South Africa. So it's not a question of saying customary law is outdated or antiquated and should not be applied. But if you look at the Constitution, as with most countries' constitutions to which all other laws of the nation should apply, then anything has to be in accordance with the Constitution. And what Justice Langa says is the exclusion of women from the inheritance on the grounds of gender is a clear violation of Section 9 of the Constitution, which is their equality provision. It's a form of discrimination that entrenches past patterns of disadvantage among a vulnerable group, which is exacerbated by old notions of patriarchy and male domination incompatible with the guarantee of equality under this constitutional order. So, in the end result, the application of the section is struck down, and what the court says it's going to do is it has to find a way to have customary law become relevant in the new constitutional order, which is a quick nutshell of what I was going to say.
Great. So we've had Justice Gouge telling us about the three-pronged test of the substantive law. And then we have Joel infusing a rather insightful concept of intersectionality, and without that, how people can go without the protection of the law that even the law set out to grant for people. And we're going to have Joanne telling us to what extent are the systems even comparable? Are they comparable at all? How does a policy of non-racialist imposed apartheid South Africa affect the capacity to respond to a critique based on Aboriginality? And can we take any lessons from this comparison process? So she's going to bring those two together, and in her own articulate way, she's going to braid them together and give them back to you.
Now, does that not sound like a teeny tiny bit of pressure? Okay, I'm trying to breathe, let me get mellow here. What I actually am doing is actually sharing reflections with you. South Africa, for me, is a site of a lot of intellectual inspiration for me. And when I say inspiration, in terms of both the positive and negative sense, the history that it's had, the challenges they face, the creativity and the dynamism of their constitution, and at the same time, the extent to which they will transcend certain realities around how structural inequality works. So I find it, I've been there 3 times, and I know I'll be going back repeatedly, because I find that opportunity to place myself in the space as opposed to just reading the decisions from a distance, is really quite, how do I say, it's not just refreshing. I think sometimes you need to have the boxes in your mind and the categories completely shaken up, and South Africa does that for me. The other piece why I think it's important to think about this is because we are, as you know, we're in Black History Month, and this is the Law Society's Black History Month event. And a lot of what Black History Month is about a challenge to functional amnesia. It's a fundamental way of saying to the broader society, not just, oh, remember there are Black people in your midst, but also to draw, by saying Black History Month, to draw the reality of our experience as Black people into the present moment, and at least for that period of time have the full legitimacy to articulate that. So it's a very interesting thing to be making that comparison between ourselves and South Africa in that context, because there are some interesting and disturbing links, and at the same time some quite distinct pieces. One of the most obvious is obviously the colonial moment. When we talk about colonialism is, and there are different definitions and different ways you'll hear it described, but fundamentally from my perspective it's the birth of international law. Basically, Europeans construct their structure of international law to regulate their capacity to exploit the land of resources that don't belong to them. That's fundamentally what happens. And that legal system has continued to have this guise of neutrality and objectivity, and it served to mask fundamental racist stereotypes. It was braided into religious precepts and other things, all with the same goal in mind: economic and resource exploitation of lands belonging to indigenous peoples outside of the jurisdiction of European countries. That's what makes it international law, in my view. The law of these domestic nations were placed somewhere else. And in that context, interesting pieces happened. Not the least of which was, as we know certainly from an American, as in the broader America's perspective, the commodification of Black people as part of that process. But it is actually something that all indigenous peoples faced: the simultaneous dispossession of their land, and at the same time, the way in which the law became the instrument of the dispossession, the reinforcing of the authority to dispossess, and actually a reconstruction of legal identity so that they no longer by law had their full humanity. They were completely defined out of the operation of law, and somehow that law was still just. Now, at the same time, when that law came into contact with indigenous systems of operation, it often attacked those cultural constructs. But when you look at what did they attack, whether you're talking about Canada in terms of the potlatch, or you're looking at South Africa, the operation of the law was often to attack the countervailing centers of resistance. They didn't really care about the pieces that weren't important to them. They cared if there was an indigenous economic trading mechanism that might have been at odds and competition for them. Hence, you will outlaw the potlatch. They cared about if you're the Khoikhoi and your wealth is in cattle and you're trying to build an agricultural community and you need to exploit that, well then you better have a way to get their cattle, keep their cattle, and deny them access to agricultural land, right? It's just a simple logic. Not right, but there is a logic to it. So when you look at the South African experience, what you see is a series of legislative pieces, and we think of it in terms of apartheid. Apartheid's 1948. That's way too close to us. You got to go further back to see a series of legislative decisions that all move towards one set of basic things: regulating black movement, controlling black labor, maximizing access to black labor, restricting all indigenous practices so that there's no longer any dynamism about it, and also regulating women, because that's a key piece, right? So you also, and this is the nice Canadian intersection, you had 8 reserves created there, and reserves they were, by any stretch of the imagination, borrowed from our wonderful little experiments at this end of the world. So, and with the same purpose and the same kinds of conversation. So on one hand, you have this critical piece that I've just described of wanting to regulate and control, but you will also find very interesting language that we're really doing it because we're trying to protect them. They need to be separate because they need to be nurtured. Now, granted, they need to be nurtured in both cases on pieces of property in a world at that time that values agricultural exploitation that they know is not going to be able to grow a damn thing. Like, I remember going to Ciskei and standing in a dust bowl, right, and thinking how you could possibly think this is going to be the site where women and children are supposed to be and they're going to have a viable life. That's absolutely ridiculous, right? But it works well on paper, and you don't look evil. Not to say that the colonizer was evil. Whether you get there, I don't know, but, I don't want to go down that path. One of the pieces that makes for a different context between Canada and South Africa, however, is one of demographics. And the demographics actually relates largely to the passage of time. There's a book by Stannard which talks about American Holocaust, and what's interesting about the context of it is to talk about how rich and diverse were the Aboriginal communities that were across the Americas and how they were systematically wiped out. So we live in a contemporary context where Aboriginal peoples in their own territories are minorities. That actually does shape what some of the legal responses are. So we will get, for example, the constitutionalization of Aboriginal entitlement in Section 25 and 35, but you will also get a dynamic, a political dynamic that's always a constant struggle for power to articulate entitlement. That's very different. In South Africa, you had a legal regime that was significantly oppressive. But in the present context, and I find an interesting way, they refer to a construct of non-racialism. Well, they can refer to non-racialism because in part they're relying on the fact that they're now the majority, right? The ANC government in the most recent election was 70%. Blacks are over 60% of the population, black people. So there's a different level, there's a different relationship between the instrumentality of law and legal policy in that context than there is between Aboriginal peoples, as a whole collectivity, in the Canadian context. I think that makes for some interesting differences. Not necessarily quite the advantages I think that it might seem in the South African context. I'm going to skim over what is obviously a very complex set of questions, but to suggest that there are a couple of observations I have, and this touches in part on some of the earlier comments. One is the fundamental difference in the culture of their courts. And with all due respect to our Supreme Court of Canada, they're far more removed from the people than the South African Constitutional Court is. It's a fascinating thing to actually sit in the courtroom and observe that court in action, where you'll have lawyers making their legal arguments, very learned, everything's all good to go, and you suddenly have a judge looking out at them saying, excuse me, so what exactly does that have to do with fairness? And the lawyer goes back to their text and, excuse me, no, I read everything, I understand it, I'm trying to figure out what you're trying to get me to do because what you're saying doesn't sound fair, right? And that is an amazing thing because as a member of that audience, even if you weren't a lawyer, you actually know what's on the minds of the judges. You actually understand it. It's not veiled in legal tests and legal arguments and discussion. There's a sense of them speaking directly to the people. There's a way in which, for example, when issues of economics comes up, in one swoop, things that, certainly with the work I do, you desperately wait for the court to actually talk about the fact that you can't talk about economics or socioeconomics without fundamentally thinking about equality. All of a sudden, the chief judge of the court looks out and says, well, in one of the cases I observed, excuse me, but the definition here has got to be one that intersects with equality. Just says it off the top, suddenly that's the position, and you're thinking, good to go. But what do you have? You have a court made up of a number of people who went through the liberation struggle in South Africa. They lived, breathed an expectation of fundamental justice and get it in a very different way. They lived in the space and know who those people are who come before them. And I think that creates a fundamentally different dynamic in terms of how they go through that. Whether South Africa will sustain that in its jurisprudence as they go through another generation or two of judges who don't have that liberation experience, I am not certain. That is a big question in my mind about what it means to move from that space through one or two generations to see what is going to happen. But right now, they're the foundation of the jurisprudence. It actually will be, in my view, the same tension we're seeing between Mandela's leadership and Mbeki's style of leadership. That is one of the fundamental tensions. That difference of that lived experience, that vision, the fullness and depth of the construction versus what is competent leadership, but not necessarily the same kind of transcendent leadership. And that may be the same tension that the court faces. So I throw that out as a sort of question and comment. The other piece is in the area of land reform. Because they're a majority and they're looking at such a vast amount of reconstruction that's necessary, I would say that there's a fundamental difference between our land claims process, with all of its flaws, but what it contains in its best view, and what they're doing in South Africa. There's a whole thrust of it that is really fundamentally about poverty alleviation. You have masses of people who don't have infrastructure. When I talk about infrastructure, I mean simple things. They do not have water lines, electrical lines, sewage lines. They don't have housing. They're in informal settlements. Even if the South African government was the most amazingly managed government on the planet, they would have a resource gap of significant proportions to deliver in the short term to all of those people who are desperately in need. So I think that would be a fundamental piece. Fortunately, I don't have, as many of you know, any notes or pages to refer to, so I can probably keep to this time. I have no ideas. I'm just floating them out to you here. But what I want to say is that in that context of looking at what that has meant for South Africa, is that I wonder whether they will have a tension not identical to the Zimbabwe tension, but a similarity to it. Our Aboriginal land claims process, when it works, provides for infrastructure that reinforces cultural capacity. People get control of land, they get control of resources, they don't have alienation of property. There's no danger of immediately losing control of that property within a generation or two. It's not a private property model. You have a capacity to build economic control and empowerment in that context. You have all of those pieces in the most successful land claims. For example, the most recent and I think most successful would be Nunavut. In the South African context, you're having these transfers happening in an atomized way amongst individuals and family units. Some people are doing it at a larger level where you're talking about extended family units, purchase of wineries and things like that, where there is some opportunity for economic development. But many of the other people with the level of economic literacy, literally in South Africa, 60% of South Africans do not have a bank account. If you simply map that against the economics, right, you know who that 60% must be. It's not 60% in every category. The penetration into the white community is going to be significant, and it's going to be relatively significant in the category that's originally Indian and colored, for a simple reason. Blacks did not have mandatory need for education. They dropped out at the end of grade 2 when I studied it. You need a bank account if you have money. You've got a job. You own something. So that's a huge problem if you're using a private property model to transform the land entitlement, because you need literacy about economics. And part of that, mortgages, all of those different pieces come from owning, borrowing, knowing. And I see that, this is my observation as an outsider when I went there to look at the cases, as a crisis that is acknowledged, but I don't think acknowledged in the most fundamental ways. But I throw those ideas out there for you, and I hope somebody asks me a question fundamentally about the Aboriginality piece and reparations, hint, and then I can talk about that. So thank you.
Thank you, Joanne. If Blackstone was alive today, he certainly disagree with you that colonialism was the genesis of international law. But what you have actually said, you have focused on two significant pieces, and that's social and economic factors, and how the court weave those things in their adjudication of cases. And I think what Estella is going to do is to tell us how those pieces or those factors, social and economic factors, can be used in the Canadian and South African paradigm in order to bring about this dialogue that constitutional professors like to talk about between the court and the legislation.
Thank you. In the spirit of Black history, what I'm going to start off is with a Chiganda saying that is from Uganda, which I think is appropriate for this discussion about what is considered to be some of the best documents around the world. And the saying goes, "Atanaita itaya tenda nyino kufumba," meaning a person who has not tasted other people's cooking always believes that their mother is the best cook. So, I'll get to it. I hope I'll get to it. At one point, I'll be able to explain it, and I hope I'll be able to talk to you about another. Louder? Okay. I think I have to bring this right in my face. Is this better? Yes. Okay. All right. Well, I hope I have a chance to elaborate on that. But I will briefly introduce for our discussion the equality rights provision in Canada and South Africa. And I will follow that brief introduction with a discussion of socio-economic rights, relying on cases which were before the South African Constitutional Court. And if I have enough time, I will talk about enforcement of these social and economic rights in South Africa. In Canada's constitution, and I'm going to make the assumption that, I'm going to read out some of this section because I'm going to make the assumption that some people here may not have knowledge of what those particular provisions say. In Canada's constitution, the equality provisions are found in Section 15 of the Charter of Rights and Freedoms. The section provides that everyone is free from discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. There are also analogous grounds, which I would not go into. The South African Constitution Bill of Rights provides similar grounds as enumerated in Section 15. However, Section 9 of the Constitution, the South African Constitution, is written in a slightly different way, and it goes further than Section 15 of the Charter. The first part of Section 1 is similar to the Canadian part. That is, everyone is equal before and under the law. Section 9.2 talks about equality includes the full and equal enjoyment of all rights and freedoms to promote the achievement of equality, legislative and other measures designated to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. Section 9.3 states that the state may not unfairly discriminate directly or indirectly against anyone on one or more grounds, including race, gender, sex, pregnancy, marital status, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, culture, language, and birth. Yes, I heard a wow. The South African Constitution adds to what the Canadian Constitution doesn't have. And I'll pull out what the Canadian Constitution doesn't have. And that is gender, pregnancy, marital status, social origin, conscience, culture, language, and birth. I believe that social origin may be referring to class, but that is debatable. Interestingly, disability is not elaborated on. They just say, they don't talk about whether it's mental or physical, whereas Canada just does that. There are two sections which I will not go to in the interest of time. Unlike Canada, which has the concept of dignity discussed in case law in order to apply to equality, the South African Constitution goes further. It provides for human dignity within its constitution, and that is really, really important to note. Section 10 of the South African Constitution provides that everyone has inherent dignity and the right to have their dignity respected and protected. What makes the South African Constitution unique, however, is the inclusion of social and economic rights within that Constitution. To me, the sections of interest are as follows. Section 26, which provides for the right to adequate housing. Section 27, which provides for the right to have access to health care, food, water, and education. Section 29, which provides for the right to basic education, including basic adult education. The inclusion of social and economic rights in the Constitution has been applauded as progressive by many scholars, judges, and politicians. Nevertheless, there have been dissenters and the debate is ongoing. Before I add to that debate, I want to remind everyone here that all constitutional documents are committed to the rule of law. However, these same documents also can tell us about the political and the prevailing legal culture at the time the document was drafted, certified, and accepted by a particular society. So it is that the major difference between the Canadian and South African Constitution is rooted in each country's history. The tensions created by the Bill of Rights within the South African Constitution cannot be compared to that of the Canadian Charter of Rights and Freedoms. Each has a background and a foundation for the formulation of equality provisions. It is obvious that the provisions of equality in Canada are not overwhelmed by the shadow of apartheid. The provisions in Canada are not situated in a lived segregation experienced by the majority of South Africans. In response to their history, their current needs and future prospects of developing a progressive society, the South Africans have borrowed from provisions from other countries. They've debated and tweaked those provisions to suit their wishes in order to create a document that they believed would respond to their needs and meet the South African society where it is situated today. And one can say that this is a globalized, using the word globalization everywhere, you can say this is a globalized constitution. But what has been debated is the fact that the 1996 Constitution includes enforceable social economic rights. So far, there are 4 cases that concern social and economic rights, namely Subramoni against Minister of Health KwaZulu-Natal, that was in 1998, the Government of Republic of South Africa and others versus Grootboom, 2001, Minister of Health versus Treatment Action Campaign 2, and I'll refer to it as TAC later on, and COSA, against Minister of Social Development, which is the most recent in 2004. Grootboom and others laid the foundation for the adjudication of social and economic rights. And I'm going to briefly give you the facts in Grootboom. Ms. Grootboom and others lived in an informal settlement in an area prone to flooding. Many had applied for low-cost housing and had been on the waiting list for many years. They had not received any indication when the housing would be available. Just before the winter rains, the respondents left the settlement and erected shacks on vacant land which had better drainage. Unfortunately, that land was privately owned and they were evicted. They then made a claim for their right to adequate housing, according to Section 26(1) and 2 of the South African Constitution, which calls for the government, and I'll quote, to take reasonable legislative and other measures within its available resources to achieve the progressive realization of the right of anyone to adequate housing. Interestingly, and this is an aside from what I'm saying, that same year in 2001, That is the year in which Grootboom was decided by the South African Constitutional Court. The Canadian Human Rights Commission, with its counterparts, intervened at the Supreme Court of Canada in the Gosselin case. And to give you an idea of what Gosselin was, Gosselin focused on Quebec's regulation respecting social aid, including whether they violated equality rights by excluding people between ages 18 and 30 from their purview, and whether they violated the right to security of the person. It was argued by the interveners that the International Covenant on Economic, Social, and Cultural Rights should serve as a persuasive guide to the interpretation of the Charter of Rights and Freedoms. This did not happen, and the efforts to add social and economic rights as an analogous ground to equality rights in Canada fizzled out. In South Africa, however, Grootboom had caused a stir and debate for and against the decision. Grootboom raised expectations and great criticism. In his judgment, Justice Yacoob had said that the respondents, and I quote, were evicted prematurely and inhumanely in a manner reminiscent of apartheid-style evictions. So here we see that shadow of apartheid and the way the people were treated coming not far behind. The court held that those in immediate and desperate need of shelter had been unduly excluded from the state's housing program and ought to be accorded a measure of priority by the states. Thus, the court found that the housing program was invalid to the extent that it failed to provide emergency relief to people without any form of shelter. Although Grootboom was not a case about equality, it was, however, rooted and influenced by equality principles within the Constitution. And this is evidenced, again, by Justice Yacoob's ruling, and I quote what he said, that the right to adequate housing has a close relationship with other socio-economic rights, all of which must be read together in the setting of the Constitution as a whole, with regard to social and historical context. I have time to talk about enforcement, and I see that blue slip coming, and I'm going to ignore it.
We'll hold it up for a minute or two.
We'll just pretend.
We'll just stop it right here.
La la la.
30 seconds. I can't do much in 30 seconds, so I'm going to borrow 2 minutes from the summary that will be made. Can I? Okay. In Grootboom, it can be said that the court recognized that it was not qualified to dictate how the state should attend to the needs of the people without shelter. However, the court managed to strike a balance in its interpretation of Section 26(2), that is the right to adequate housing, which provides, I told you about it. Now, I can't help it, but I'll get to an aside to it. If one looks at international covenants, the right to adequate housing is embedded in the Universal Declaration of Human Rights and major human rights treaties, such as the International Covenant on Economic, Social, and Cultural Rights. The wording in the South African Constitution in Section 26(2) is borrowed from there. Then it is modified to fit the South African Constitution canvas. The Canadian judges, the judiciary, or let's say the legal part of the framework has not looked there, even if they've tried. Canada in Gosselin, which I talked to you about earlier, they tried to bring this, saying Canada is held by, always signs to the international covenants, and in this case, it should make a ruling based on that international covenant. It didn't do so. South Africa, it has it embedded in its constitution, and it's trying to enforce that. Well, due to the fact that all the squatters may not, that is in Grootboom, due to the fact that all the squatters may not have had housing availed to them, even as we speak today, there has been a lot of discussion about enforcement of socio-economic rights through the Constitutional Court in South Africa. However, the pressure has abated a little. As far as I can tell, there has been a lot of progress made by the courts, and a clearer picture of enforcement of socioeconomic rights has emerged through the two recent court decisions. That is TAC, Treatment Action Campaign. And this is a case about states restricting the availability of nevirapine to meet health needs of mothers with HIV/AIDS who were transmitting the disease through breast milk to their newborn babies. The issue before the court was whether the women and children had been unjustifiably excluded from receiving the drugs. The court found that they had, and it required the government to give reasons for its policy. The government said that nevirapine was toxic and could give rise to resistant strains of HIV/AIDS. As an aside again, they were right, because recently it's been published that nevirapine is not the best drug to be used. Nevertheless, the court was not convinced by the reasoning, and it ordered the government to make the drug available to all public hospitals. In addition, the government was ordered to take reasonable measures to extend testing and counseling facilities. The court went beyond Grootboom in this TAC decision because it developed a more assertive approach to the enforcement of social economic rights. Whereas in Grootboom, the court was more collaborative with the state, and it provided broad guidelines which required the state to implement a program catering to the needs of the people in need of housing. And also in Grootboom, the court didn't recognize housing on demand, or an individual could come off the street and say, I'm entitled to housing. It didn't recognize that. But we find that in TAC, an HIV-positive pregnant woman is able to claim as a matter of right a single dose of nevirapine at any public health facility in South Africa where the drug is medically indicated and where testing and counseling are available. The last case I will talk about is the COSA. This one is the question before the Constitutional Court was whether permanent residents are entitled to social assistance, which some people may find strange, but when you're looking at, I hope I can discuss this further because there are other cases which are about permanent residents in Canada, like the Tran case that was before the courts, and to me it's related, and the court threw it out in Canada, whereas in South Africa they've been able to enforce this. I hope we can talk about that later. In South Africa, social grants were reserved for citizens. The state argued that its primary obligation was to its citizens, and that the financial repercussions for extending social grants to permanent residents would be onerous, and it was, in a sense, trying to encourage self-sufficiency. The court, nevertheless, rejected the arguments and ordered the government to extend social assistance to all permanent residents who met the relevant criteria. The argument in some quarters has been that with respect to socioeconomic rights, courts are not equipped or well suited to adjudicate in such matters. The idea behind this argument is that socioeconomic rights are positive rights, which require a lot of resources to be actualized by government. Therefore, they should not be brought before judges. I would argue, however, that the South African Constitutional Court has shown that it is possible to adjudicate in such matters. The judges in that court have shown that they are able to balance the requirement to correct the wrong without usurping the power of the state or unnecessarily dictating to the state. They have shown that it can be done by giving broad guidelines to the state, which the state is required to follow, and where necessary, it's ordered the state to act. Given that the resources can be a major stumbling block and the poverty intersects in most of the claims that come before the courts, the Constitutional Court, where many resources are concerned, just like Canadian courts have done, deferred to government. I expect, though, that the South African court will at one point defer to government, and that would be in the future. But their deference, I hope, will stick to Grootboom, the way they have dealt with Grootboom, in the sense that they've given broad guidelines. 2 extra seconds?
No, no, she's saying
Okay. So I'll stop there, And thank you.
Now, we have heard from 4 very informative speakers, and they have actually given us a lot of information. Some of it is edifying, some of it, no doubt, has piqued your curiosity and you're asking questions. And so we are going to very shortly turn the floor over to people to ask questions. But before I do so, there is a common theme in all the speakers' presentations, and they speak about the ordering of adjudication. We move from the three-pronged test that was established for the substantive determination of cases. We hear about the intersectionality that should be infused in that three-pronged test. Then we heard about the involvement of the court and the court having lived the lives of the people and so is able to impart that knowledge and experience in the adjudication. We hear about how the constitutional text itself has mentioned social and economic factors as grounds in the Constitution. And interestingly, we hear that the text itself expressly lists dignity as a function of the protection of rights. And so we know, and I'm keeping it local, in Ontario, the Human Rights Code in its preamble, and I say preamble, recognizes the dignity of all persons. But there is no such term in Section 15 of the Charter. And so when one do a comparative analysis with the text of our Ontario Human Rights Code and the Section 15 of the Charter, and the absence thereof of specific rights of economic and social factors, and we hear how they have actually been braided in and weaved into the adjudication of substantive rights and also in the application. What I need to ask each speaker, if they could comment briefly on, if we had those things present in Canada, would that alter the adjudication, in particular the remedy?
I don't necessarily think so. I think one of the fundamental differences I was naming was the actual culture and context of the court. And in my view, even some of the direction, the way we use dignity has problematic elements to it. What is making it different is how you take a term and what content you infuse it with and what the context is, the conceptual framework you're using as adjudicators. So it doesn't necessarily automatically mean if we had embedded the same terminology, that the terminology would mean and have the same impact. I would actually hazard a guess that it would not, because if you leave that aside, we have had a fundamental resistance to dealing with, for example, issues of race throughout, right? So even the Human Rights Commission with this dignity clause there, disproportionate failure rates across the commissions in that area. So the realities of institutional racism, etc., have not been enhanced whether the word is there or it's not there. What you need is a particular conceptual framework in the minds of the adjudicators, plus what you have in South Africa, which I don't think we consistently have here, is counsel who are actually assisting the court because they see their job as infusing it with this critical perspective. So the courts are also not on their own in a vacuum. They're actually building on this radical analysis that's placed before them, very active and well-developed NGO and interveners that are there as well. And I don't think that's a comparison where I certainly think they're more advantaged than we are.
Justice Gouch?
That's a big question. I mean, it is intriguing when you hear the speakers how much interchange there's been between countries like South Africa and Canada. the explicit concept of human dignity is something that's come to the forefront, whatever its content, and Joanne is quite right to focus on the words themselves are fairly meaningless without knowing how the receptacle is going to be filled, but the words are there. They don't appear in any of the language of Section 15, but they're now embedded in Section 15 analysis. I suspect, and this is just my own suspicion, I confess, I suspect in quite large measure because of the interchange almost at a personal level between judges from the South African Constitutional Court and judges of our Supreme Court. And what is expressed in the South African Constitution, not expressed in the Canadian Constitution, obviously has resonated with our senior judges. And they at least begin with the adoption of the concept. It remains, as I said when I had a few minutes, for the next generation to infuse it with as much vigor as possible. Interesting to compare it as you listen to Estella talk. Why hasn't the same happened with social and economic rights? They're expressed in the South African Constitution. They have stopped short of any inferential infusion into our equality law, almost quite expressly. We've heard about the Gosland case, and there is clearly, and for me this is one of the battlegrounds of the next 10 or 15 years, the battle between the majoritarian forces who propound parliamentary democracy and the minority protection rights in the Charter. And that's a significant battle, and it comes really, I think, to a crisis when one talks about what role the courts, if any, are going to have in determining the diversion of economic resources. We saw it in Gosland, none. We saw it in the recent autism case out of BC, none. And that has to do with what I think is perceived in Canada as a deeply embedded right of parliamentarians to control how money is spent, regardless of its impact on disadvantage. We haven't borrowed the concept through a kind of constitutional common law the way we borrowed dignity. So I close with the question, why not?
Maybe Joelle might want to even elaborate on why not.
I wanted to elaborate on something else, but maybe I cannot do that. Just to add to what Joanne and Justice Gouge have said about dignity, the big deal is not that it doesn't exist in Canadian legislation. Interestingly enough, when the South Africans interpret their Section 10, which is their dignity provision, they refer to obiter or main comments from the Canadian Supreme Court. Almost every Canadian or every South African reference dignity makes reference to the Canadian Supreme Court. Most often, I think it's Lura Jabay or Justice McLaughlin in the Egan case about how Canadians have developed dignity. So the fact that it's not in our Constitution is not the big deal. But what is interesting, and this is also too about the big relationship between Canada and South Africa, I think as most of you know, the South African Constitution is modeled very closely on the Canadian one. So there has been sort of, a parallel movement in terms of equality analysis in both courts. But I think now what is happening, and if you look at South Africa taking Canadian obiter and then applying that into their own analysis as far as to dignity and equality goes, is South Africa is leading the way as far as equality analysis goes. And they do that, yes, with still strong reference to the Canadian court. But, the current test that we use now, as Justice Gouge expounded in the law case, is based pretty much on what the South Africans developed 2 years prior to that in the Harkson and Lane case. So there are similarities, but I think there's been a passing of the baton, so to speak, in terms of who is leading the way in terms of that analysis.
Estella?
I think everybody has said what I would say, so I could shut up.
Well, Justice Gouge has an extra thought.
I don't often have these, so I just wanted to underline something Joanne said, which struck me as really quite an interesting concept. And Joelle just spoke of it. That is the equality vigor that the South African Constitution and the jurisprudence under it seems to have developed. And this is really for legal historians, I suppose, but we in Canada who populate the institutions that do this stuff haven't lived through a liberation. We've lived a pacific, untroubled existence by and large. not tempered by any of the kinds of struggles that, I mean, when you listen to Albie Sachs, you kind of see it, you know? And you wonder how much that has to do with the vigor that gets infused in the jurisprudence. I don't know, but it's an insightful perception that I think is worth reflecting on, because it may underline something else we have to make up for.
And I think Joanne alluded to that when she said that this is the dynamics now of the current legal regime. And so it's to wait and see what would happen in the next generation when they become judges. And so I'm wondering what guidance would they take from the jurisprudence that these very, I'd say, equality blazers have left behind. So, ladies and gentlemen, you've been
Can I say something
Oh,
before?
certainly, I'm sorry.
One thing that
She's now
Doing
decided
very
to speak.
well. Doing
Yes.
very well. They're very
One thing that I just want to throw back to everybody is when we talk about dignity, and it shouldn't be in the Constitution, it doesn't have to be, it need not be listed or written down anywhere. The concern I have about dignity is the way it can easily be interpreted and the way it can be used by a person who has not experienced what a historically disadvantaged person would be presenting before the court. And the danger in that, if you look at Sheila Martin's paper on dignity and Kent Roach's paper on remedies, you get to know where we may be heading with this. And if we're not careful and we use dignity as the center of the decision in equality rights, we're going down a slippery slope whereby we may end up hurting rather than upholding the rights of equality seekers, because any person can claim that my dignity has been infringed, and then the issue becomes, what do we mean by dignity? So that's my only comment that
I think what Estella has just basically said to us is the old aphorism of walking in the moccasins idea, like having that full experience. So you've heard it from our speakers, and if you can take away nothing, you take away this. Human rights texts, constitutional texts, they are lifeless. And they only have the meaning that's infused in them by the adjudicators and the people who actually interpret them. And so the people who are placed in these positions must, as you hear the speakers say, be armed with those tools of construction, of sensitivity, of understanding, so that they can infuse these very real tools in the determination of people's lives. And it is a frightening thing to do when you sit to adjudicate matters of people's lives and know what profound effect it will have on them. So I think they have all said to Dickens today when he said the law is an ass, he was wrong. It's the interpreters of the law who could be the asses. I've seen many hands. Well, I've seen many hands who want to ask us questions. So we are now moving away from the planted panel from the chair, and we're moving into our audience. And I think the first hand I saw was Yola Grant. Yola, stand a toe and tell us what you want to ask us.
Involved with the anti-apartheid struggle. I practice law here, and I've sort of fallen out of I haven't had time to read lately, so I'm going to press you, particularly Joelle, since you're studying in Cape Town.
I only study the mountains, though, really.
There was a huge debate about property rights and entrenching it, and of course in the South African context I could only be in favor of whites who had property to defend. And there was some reliance on the Canadian debates around property rights and also the previous Canadian Bill of Rights, and it seemed to have won the day. And so the South African Charter did not expressly include property rights. I'm wondering if you can comment, though, about whether the use of dignity, as in laws, take it to some extreme, or any or social and economic rights, if there are any cases coming forward that are essentially seeking to entrench privilege. under the guise of not allowing for a confiscation of, property of those who are already settled, where there's obviously a government in place, and with the likes of Albie Sachs, who lost his arm because he was a member of the ANC heading that court, we can be somewhat assured that they won't forget their history immediately. But I'm wondering if there are any attempts being made by litigants to get through the back door.
Joanne's really itching to say something
No,
here, but
because-
first I'm going to make a quick
I think,
comment.
yeah,
Okay.
That's what I'm saying.
Okay. Yola, I think as far as property rights go, I don't know too much about the private property aspect of it, which is what I think you're alluding to. Estella didn't go into it in too much detail. Maybe she also wants to elaborate on this comment, but the Grutenboom case is the closest thing to access to property and land that South African equality activists are now looking at. The issue in that was not just about getting people, out of a rainy field and into temporary shelter, but it was about allocating housing, which is a constitutional right for South Africans to people. So I think there is a government impetus and definitely a desire to deal with property rights generally, but the practical aspect of it is burdened by economics and just the mass number of people which require housing. I don't think that there's any inhibitions or anything. It's just that there are too many people who require land and housing, and just not a mechanism which to do that, because they're dealing with deconstructing all of the provisions from the prior regime, which were all about denying access to property for certain groups of people. I don't know if Estella or Joanne have something else.
I think the difference is, what I'm sensing in your question is whether the solution is actually within the definition of property rights itself in the like using a litigation-based kind of response. And my immediate reaction, which is what I was focused on, is that it's more akin to our land claims process. I would make the comparison. We have Aboriginal title cases, and we can talk about how effective we think those Aboriginal title cases are in Canada. But we have, when we settle land claims, very significant remedies that come out of a land claims case. The distinction in South Africa is there actually is a land reform regime. So this is not a case of a vacuum in the legislation and the conversation where all of the individual litigants have to do it.
Private property.
Yeah, but you're talking about being able to what? Own.
Private property rights, how do they, when you're running into this redistributive government, are people using the charter to say, you can't take my property?
Yes, that's what I'm going, that's exactly, because there is a recent case, that actually the one I observed when I was there. So what they did was they created this administrative regime, which is built on a willing buyer, willing seller kind of principle. Now, where you're seeing the private property question is arising in a recent case, which involves, think about a typical thing. I want to sell my property to you, but my property, I had a tenant on my property. So I'll just explain the scenario which the court was faced with. You had an individual who wished to purchase property, so they would be a bona fide purchaser for value without notice, i.e. they would be a person entitled to purchase. I transfer the property to them. In the meantime, my tenant has been living in that property, and they may not have been paying their various taxes, i.e. water taxes, electrical taxes, electricity, et cetera, So you now have a municipality, and in South Africa this is a crisis. The municipalities are dependent on a tax base that is already fragile, where you have masses of individuals who are defaulting on actually paying what is required as the tenants. The absentee landlord says, I don't owe anything. It was their responsibility, and I'm also entitled because of my property. It's my property interest. I should be able to devise it as somebody else. So you had the municipality saying, no, we don't want you to be able to exercise that capacity for exchange until you take responsibility. Someone has to take responsibility to pay us back for the default in terms of these taxes. So what I saw in that case was actually all the different pieces were coming up. What was the obligation of the tenant? What was their relationship? What was their property interest? What was the interest of the individual landowner? What was the role of the municipalities? And how did that fit in a culture of South Africa where people were used to defaulting in part because they weren't used to supporting an apartheid government? And so that had transferred over into the post-apartheid government relationship in terms of the payments. And so you had Justice Yacoub naming it very directly, saying, I understand you're talking about a property interest here and a private interest that would work, but it can't work practically speaking here. It's not simply about whether the municipalities are well run, he said. It's an issue about whether there is, and that's the tension in South Africa, this capacity to move from a wholly individualistic construction of property to an understanding that there's a broader social responsibility. And in the byplay in the court, because I stayed for whole sections of the argument, you found Justice Yacoub, Justice Langa, Chakelson, and O'Regan all coming back to the same question. We still need to know who's to bear this burden if we uphold a strict private property interest as you've defined it. Is this appropriate? Because at the end of the day, this tax base has to serve the broader community in terms of health and other things. So I think that's what you're getting at. So I think that they've actually sunk their teeth into exactly what the nature of the tension is, and they're seeing more of those types of things coming up where it's no longer a black-white issue. The litigants were a mixed bag in this case. The person who wanted to purchase the property was black, a black woman who was actually saying, this is why I've lived through this experience, to be able to get this property. You know, and so that was part of the tension. It wasn't just simply this notion of it was a white-to-white transfer. You know, so all of the sort of enmeshment of these different issues. So I think that's going to happen more and more as people see themselves as distinct from having loyalty to a liberation government. You saw that in the last election, that they actually voted on that basis. They're moving further and further away from that and just simply getting more and more to entitlements. And so I think at that point, you'll start seeing more cases where people are attempting to use a litigation strategy. But when I was there hadn't been a significant use of it. This was the one I found that was the most significant in an attempt to grapple with those issues. So there hasn't been a lot, but I think over the next while, there's going to be a lot more, and the court will have to flesh out the tension.
Yola, that was a rather teasing question. Any more questions from the, I think what we're going to do, we're actually limited in time. We've got 15 minutes left. So I'm going to ask that those who have questions, if you'd stand so that we can actually deal with you, okay? So we have the first person standing there.
There's somebody there and there's somebody
Yes, we have a gentleman standing there.
Yeah.
So we have 1, 2, 3. Thank you. Oh, you can. Yes. Ma'am?
This question is for Jewel mostly, but also for anybody who can comment on it. It's a $1 million question. It's not maybe particularly one that a lawyer could answer, but maybe you could help me anyways. Do you have a prediction as to whether all customary law involving sexual discrimination will fall? And if you could tell me what your prediction is, could you then tell me why you think that will come to pass, or whatever will come to pass?
Okay. So that's our first question. Justice Gouge, if I may be his amplifier. Terrific question. We have a second question there, sir.
My question is specifically for Africans of Canadians of African origin. I would like to know the impact of W.E.B. Du Bois and Booker T. Washington upon the African community in Canada, and what this community has done intellectually to educate its members to stand for their rights, and who are the famous African intellectuals in Canada that can be compared with the people economy.
Thank you, sir. And then we have a third question there. I hope the panel is making notes of these questions.
I have a very good question, and I was wondering whether there's any substantial distinction between the South African Constitution and the Canadian Constitution, in the sense that, and I think I've heard something that you said, Stella, about the socio-economic provisions. Does the South African Constitution impose a positive duty and obligation on the legislature to take action, as opposed to Canadian Constitution simply saying legislature, Parliament, when you do something, don't breach these rights? Is there a distinction, and is it an important distinction between the two?
Interesting question, too. Okay. Oh,
If there's time permitting. Estella mentioned during your presentation, I believe you referred to the Tran case, and you said that you, if time permitted, that you would like to comment on something about that. So if time permitting, and if you would still like to do that, I would like to hear it. I'm curious.
ladies and gentlemen, I think we've closed the question, and I think we're going to have to allow the last question because this is our MC. He's planning some entertainment for us tonight, and if we don't, he may not really deliver. So we are going to. Let's start with the first question first. Joanne, do you want to take a go at it? I mean, I know this is in your realm of gender issues, and it's not that you're a fortune teller or you're clairvoyant, but it's interesting to hear your comments about the prediction. Would that fall?
Right now, the main area that they've been looking at would be, for example, in the area of intestate succession. And it appears to be that the gender analysis, there's such a direct conflict that there is, the gender analysis will, to a certain extent, be evacuating whole aspects of customary law, because at the end of the day, they cannot coexist. Now, it's an interesting piece, because even when you read the entitlement to the customary law entitlement is still one that has to be able to coexist with the basic values of the overarching South African Constitution. So the question becomes, in an area like customary law, what aspects of culture could survive that test if the cultural constructs actually are based on something like primogeniture? Is there a way to actually articulate any kind of legitimacy for that? Would be what you would be hearing from the traditional chiefs. That sort of piece. But right now, the direction appears to be one to try and grapple with the gender inequality pieces, the kinds of documents that have come out of the South African Law Reform Commission in terms of developing legislation that would specifically speak to those issues. It's quite clear the direction they'd like to take. However, when you map it, and as I said, I still think it's a tension. I think ultimately there will be a weighting that will be more in favor of what we consider to be the traditional gender equality analysis. But that being said, there are going to be built-in tensions, like they've built in a Communal Land Act. They've built in voices for the traditional chiefs. The voices of the traditional chiefs will automatically make it extremely difficult to hear the women's voices. There are also some interesting pieces embedded in the legislation that are in the jurisprudence that are a bit problematic. So, for example, even in the progressive legislation, the articulation of what is traditional practice. Who is the voice of the academics? White males. I found that very, very annoying because I was trying to, I don't know how to explain it any other way. It was very annoying because when the South African Law Reform Commission did their consultation, they said 70% of the women did not want to see that reinforcement of the customary law piece, but they still managed to come with there's this other perspective. And I'm thinking, well, for heaven's sakes, if there's like 70 to 80% of the women saying they don't want something, how did you get to this viewpoint that you have a saw-off? You know, so there's still that a little bit of a shift. There's an anchoring there that's going to be a tension. But the recent literature is suggesting that it's moving very much in the other direction, that in that area, the customary law with the intestate succession, with the primogeniture pieces, that those will eventually be eroded, and culture in that area will ultimately be subordinated to some extent to a broader gender equality analysis.
Could I?
Any other panelists want to add anything to that question?
Quick.
I would actually like to. I'm actually a South African lawyer, and I've done a thesis on equality and customary law in South Africa in my master's program. And the thing that the greatest problem is divided into marriage and inheritance problems. Yeah. Those are our major problems with customary law, being subjugate to the equality rights being subjugated to customary law and customary practices that have existed from time immemorial in South Africa. And our biggest problem was our traditional leaders because they refused to back down. And South Africa is based on tribal culture. And irregardless of the education, and people will always listen to the traditional leaders. Nelson Mandela is a traditional leader. That's why the respect and the group with people will be that way.
But he was willing
yourself. Retire, so that's a great leader who's willing to step down and not.
Yes,
Yeah.
yes, but a lot of the situation is that, and but a lot of inroads have been made because in Southern African courts, I did a survey of not South Africa alone. I did all 8 Southern African courts, Botswana and Swaziland and all the others, and the biggest problem was customary rights to equality, being the largest, the biggest obstacle to equality for women in Southern Africa.
Okay, thank you.
That's really interesting.
I know, it is. We don't have that problem in Canada, do we? Dealing with all
Well,
this customary
yes,
rights.
we
Well,
do.
sure.
Unless- no,
I mean,
no,
and it rises in
let me finish my comment. In the main, when you're dealing with people from all different countries, we don't have it in so concentrated as you do in Africa.
That's right.
And maybe what you have more so when you're dealing with Aboriginal issues. But we do not, as a matter of adjudication, face with that on a daily basis. But I see it becoming more and more so with the Surrey law and all those different things
Sure.
that are
I
now
mean, Marion
being
Boyd's report is a
asking, and then
perfect example of
years
what
ago,
we have to deal
yeah,
with
years
here.
ago we dealt with that with the GET and the rabbinical laws.
Yeah.
But to the extent that is present in the adjudication of South Africa, we do not have that dynamic in Canada. Good. So now we're going to take off on the second question that was asking about the impact of Du Bois and Washington in Canada and how have they influenced us and what are we doing to teach rights. I don't know who want to take that on. Justice Gouge, I'm sure you know who.
I'm the last person you should call on to answer this question.
I'm sure you know who Washington is and Du Bois is,
Yeah.
but I shan't take you there.
Thank you.
I was just going to exclude you
Yeah.
from the question.
I think that's discriminatory.
and ask, and I should ask Joelle. What can you say about that, Joelle?
From your perspective having seen South Africa and the education system hours, can you talk about these people? Do any of us teach you?
In response to the question, which I think is a really interesting question about African Canadian intellectuals and influences, I don't know, different ways to approach it. First of all, who is an intellectual may be very different from who your greatest influences are in terms of your own intellectual development. Like they're very separate issues. I can't even say who's been my greatest, influencer. It's anybody from the people that you've mentioned: Du Bois, Booker T. Washington, Alice Walker, Toni Morrison. To the bus driver, the taxi driver in Cape Town. The person who looked after, it could be anybody you meet in your life, I think, in your experiences, and I think you're open to different sort of intellectual development and growth depending on where you are and what space you're in at a particular point in time, and I wouldn't attribute that to any one person or any set or type of people. That's how I would answer that.
Too funny. I just found your choices interesting because for me, as important as I think they are, I'm absolutely certain that I'm far more interested, sort of informed by Frantz Fanon than probably anybody else in thinking about the colonial process and its impact. And I'm not saying that they are not significant, because certainly I teach critical race theory and I talk about those ideas all the time, but I think that it's important as well to think about a broader African experience and not simply the experience that has happened immediately in the United States of America, because I would sort of say the same thing about them as I said about South Africa. Some really important points of comparison, but then some other important distinctions in terms of the immediacy of the history, and probably reflecting that my parents are from the Caribbean. That's probably another piece for me. So I would talk about people like Cyril R. James. I'd be talking about Williams. I'd be Eric Williams and a number of other people, thinking that they are also critical to thinking about it. But what holds all of these people together is a critical engagement with history, an understanding of the need for black consciousness. I mean, I would also put Steve Biko in there for me as a seminal figure that influences me. Yeah. So I think that it's whether we, certainly thinking about myself as an educator, whether we bring that forward in our classrooms and classroom environments, and whether we talk about these people and stimulate people to think about it. And I think that's an individual responsibility as well as a collective community responsibility, and that's why your question is so very important. Who do we bring forward? How do we engage students? And I don't see it as something that's just for Black students who I teach. I see it as something for my entire class. So my whole class experiences learning about these individuals because they're part of our common heritage, and it's part of our capacity to communicate with each other and to understand each other's histories and each other's positions. And so the basket of intellectuals for me are, I spoke about Black intellectuals, but for me, the basket of intellectuals that I'm influenced by are actually far broader than simply those immediate components of Black history. And I certainly don't solely look to an immediate American consciousness.
Good. I'm sorry, sir, but we do have to move on to the next question. There was a third person who, 3 out of 4 people who stood up for questions. And so we're going to move right in. And we're going to start with Estella on that question, because the questioner was asking about the distinction, if any, between substantive distinction between South African and the Canadian Constitution because of the expressed mention of the economic and social right, and whether there is a positive obligation, the question of positive obligation do you want to actually?
Yes, I believe that there is a distinction. And as I started off, I started off by saying that it's informed by the history. Like we have to start from the history of both countries. Then we will be able to realize the distinction in the formulation of the documents that came about and the documents that are there. The interesting part, though, is that in looking at social and economic rights, people think of them as positive rights. So meaning that the government has to act on them. So there's money going to be spent on any decision that is going to be made about this. So this decision, these are positive rights which should not be for the judges. And I find that, and then the other side would be that the negative rights, which are the ones where the government can enforce and do something about, then it's like, yeah, that's where we should go. Social and economic rights do not fit in that picture. I disagree, because the same judge can say, spend the money, or enforce this, can make sure that the enforcement happens. So I believe that in Canada, what makes it distinct, well, I think what is making a difference is that Canadian courts are still within that frame of we need to just deal with negative rights rather than the positive ones. Because if at all they went beyond that and felt comfortable about decisions that deal with social and economic rights, because these, for my people, the people that I represent, social and economic rights are key. Historically disadvantaged people, social and economic rights are key. You find that Black people are really poor, and the poverty just goes across board. Unemployment is rampant there. So social and economic rights are truly something that need to be addressed. Yet, because it seems to the Canadian government, and not government, the judiciary, with due deference to the judge, they look they look at the money issue, the financial part, and then they back away and say, we are going into the touchy-feely, we are getting into the positiveness here, and that is what the policymakers are supposed to do, rather than I, as a judge, should be able to adjudicate about. And I feel that shouldn't be the case. I hope that one day social and economic rights would be something that are at the table that can be an analogous ground in our equality rights. I truly hope that it's going to work. Just to plug in, there's a case that's been ongoing about the clawback. Do you know about the clawback that's happening, where the federal, where they give people on social assistance, they get money, and then it's clawed back by the provincial governments when they say that you're getting, I can't explain it very well, I'm sorry. The government, anyway, the provincial governments close that money back, whatever has been given to that person on social assistance for their children, that child benefit is clawed back. Now, if at all the courts could, I hope this case can, when it comes before the courts would be able to look at it as a social and economic right issue and be able to look deeper than the negative rights that are being that they usually rule upon and they feel comfortable about. I hope the courts would be able to get out of their comfortableness and look at the people that they're adjudicating, because that's how it is. The other thing that I feel needs to come through is this is a division of powers issue as well, where then it can be an issue about division of powers, that the judges, the courts, when they make rulings about social and economic rights, they're treading into the grounds of the legislature and the executive. So those are things that make it distinct, and that's how I feel about it. But on the other hand, as I said, the judges can still do it. They have the power to do it. They were not appointed. They are there, so they don't have that threat that they're going to leave their position, so they can do it.
Joanne, you know that there's some academics have written before about whether through the Canadian Constitution there's a positive obligation on the part of government to act, and I can think about Joel Bakken some time ago had written about that, and this is part of the gentleman's question, and that feeds right into that economic and the social factors. Do you want to actually add that to Estella's response?
I think that the only observation I have was that brief comment I made around who sits on the court. The capacity to do something and the competence to do something are two separate things. And I think there's a whole issue of whether competence flows from some aspect of expertise and capacity from having lived certain experiences. Certain things that seem fundamentally radical to do not strike those of us who live a particular experience as that radical. It doesn't seem to be such a leap of faith to talk about socioeconomics, because if you are living outside of the margins and the center of economic power, that is where you live, and you see a fundamental injustice and imbalance. So to even suggest that the status quo even remotely makes any sense is counterintuitive. A different kind of lived experience suddenly has you casting about for tools. Suddenly the world, the mirror of the world is cast askew, and you're struggling to rebalance yourself because the world is unsettled. And I think that's at the heart of what's there in the socioeconomic discussion. In South Africa, the world was askew and fundamentally obvious to the majority of that population, so that to engage in a conversation about rebalancing automatically had built into it a notion of redistribution and some sense that you would have to do something. In Canada, it's those who are on the outside who challenge and keep requesting for that rebalancing. And they may not actually be tiny community, okay? Significant number of people are poor, but they are a minority in the corridors of power where concepts are formed, whether you're talking about legal academia, other forms of academia, who are lawyers, who are judges. And so it becomes critically important that we link this conversation about conceptual transformation to who we think are entitled to be our judges and how we hold them accountable. Not because I don't think that judicial independence is critically important, but I actually think diversity on the bench is far more critical than we really believe it to be, because it's that piece, that intuitive piece, that rethinking of what is common sense in the ordinary, that's built into thinking of whether a concept is really new, whether it actually is inherently a part of something that's already there, so you're not doing something radical, you're just infusing something. All of those are strategies. So that would be more my response to it, that there is that tension that's part of it.
And perhaps, Joanne, as you so aptly put it, that could really be the reason, the real fulcrum for the tension is because that lack of understanding and therefore the inability to translate that in the adjudicative process. Mm-hmm. Excellent. Now we're going to hear about the trans case, because our MC, we must keep him comfortable.
I think Estelle's stuff.